to another episode of Supreme Decisions. And tonight, I want to talk about something that I say more often than not, and I want to stress something that I kind of repeat a lot, but now I'm going to give you a little bit more food for thought. And tonight is going to be about the Supremacy Clause. I'm going to start off with Cooper v. Aaron, 358 U.S. 1, 1958. Federal law controlled and could not be nullified by state statutes or officials. When we talk about policy not being law, when we talk about willful acts, and we talk about things such as the power of words, such as must, these are things that are applied in federal law because the Constitution is set forth and guided and enforced in federal law, and it overrides state statutes, codes, and ordinances. Why? Police officers take an oath where they swear to uphold and defend and support the United States Constitution, which is the supreme law of the land, and it is upheld through federal law. So when we talk about them acting outside of the premise of law, we're talking about them acting outside the guidelines of the Supremacy Clause. And we also talked about where there is a conflict between state statutes, codes, and ordinances and federal law takes precedence. And that is illustrated with the Selective Incorporation Doctrine, also which is shown through cases such as Louisiana v. Duncan, as well as Crosby v. National Foreign Trade Council, 530 U.S. 363 2000. Even when a state law is not in direct conflict with a federal law, the state law could still be found unconstitutional under Supremacy Clause if the state law is an obstacle to the accomplishment and execution of Congress's full purposes and objectives. This is one of those where we talk about the police are able to do something. Now, what we have to also understand is a case I talked about probably in video 4. Practice of something does not make it law. So understanding just that aspect, this is where it comes from. Just because something is practiced and unchallenged does not make it constitutional, does not make it law, and does not mean it has to be followed. And the last case I'm going to leave you with tonight is Pennsylvania v. Nelson, 350 U.S. 497, 1956. When federal interest is in an area of law is sufficiently dominant, federal law must be assumed to preclude enforcement of state laws on the same subject. So understanding the Supremacy Clause requires federal law to be the dominant law that is supported and tried. And we also know about my favorite case, Howlett v. Rose, 496 U.S. 356, 1990, because federal law and Supreme Court decisions override state statutes, codes, and ordinances. And Prince v. U.S., 521 U.S. 898, 1997, is another illustration of how the Supremacy Clause works. Understand, when we talk about clearly established law, we're talking about Supreme Court decisions that define police procedure. When that is violated, that is when they can be held liable. These are the things that we talk about when I'm speaking of willful acts, when I'm talking about officer discretion. These are the things that go into that, as well as when we're speaking about the Supremacy Clause, the supreme law of the land. This is what I'm talking about. Again, I will continue to go deeper. Let's keep going, keep growing, keep donating, and we appreciate each and every one, because again, we get to use it and we get to build from it. New software, new equipment, new areas, and allows me to do more videos, more podcasts, and to go more in depth. So until next time.
Do not try and bend the spoon. That's impossible. Instead, only try to realize the truth.
What truth?
There is no spoon.
There is no spoon?
Then you'll see that it is not the spoon that bends, it is only yourself.